a degree of protection from those who would harm her. And that protection would begin with her detectable human heartbeat, a heartbeat in which every cell in that heart has the exact same DNA as it's going to have 25 years later as a young 25-year-old woman, or 75 years later as an elderly Georgian. We have an opportunity to protect both, to protect young women and protect young women and young men before they're born. I urge you to take this first step, to celebrate life, to protect it at all stages, and I urge you to vote affirmative, to vote yes for this. I yield the balance of the time to Chairman Setzler.
Chair recognizes Chairman Setzler for the balance of the chairman's time.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, appreciate the deliberation, the thoughtfulness, and the passion that was part of this debate. 75% of the debate time was given to the minority party on this debate. We had a whole line of speakers that came and to talk to this issue because we think both sides need to be heard. There was no chilling of opportunity. There was no chilling of people's perspective. We saw line after line after line of person opposed this bill, given the opportunity to be heard. But ladies and gentlemen of the House, as we consider this question, as we consider the question before us about the human life, I appreciate the questions that were brought. We care deeply about women in this state. In fact, when you think about the services we provide for prenatal care, it's more than 2 times what we provide to other adults in settings in which they're not pregnant. Pregnant women we cover to 2.1 times the level that we cover other people in terms of care. We could go on and on and on about the leadership that we've provided in addressing the health care concerns of women. But what we get back to when we consider this question is this, friends. As I look out that window right there, I recall when I first walked into the General Assembly, I stood there in the break room and I looked outside the window, and it almost drew a tear from it. Because on March 18th, 1970, a 20-year-old college student from here in Atlanta found herself pregnant. She got pregnant in the summer of 1969, and with the liberalization of abortion laws in Georgia that this General Assembly passed in 1968, could have gone through a process to abort the child. But that mother, a fragile, scared 20-year-old college student, went to Grady Hospital and gave birth to me on March 18th, 1970. She offered me up for adoption, and 27 days later, I was put into the hands of a 27-year-old pastor and his wife who cried themselves to sleep for year after year after year of marriage without being able to have a child. Friends, that young pastor and his wife were able to adopt 2 children in the 1960s and 1970s because there were children to be had. Friends, before abortion took the lives of 25% of the children that are conceived in this state, adoption was a loving solution that was available to people throughout the state of Georgia and was used time and time and time again to give life. I can't thank my birth mother enough. I don't know who she is, but I will see her someday in heaven. And I think about the 4 kids that I have, and the kids they may have, and others, and the lives they'll touch. It all came from the gift of adoption that this General Assembly 2 years ago acted in a very bold way under the leadership, the timeless, ardent leadership of Representative Reeves, to expand access to adoption, make adoption easier, make it more viable for women to choose adoption as a choice. We acted 2 years ago as a General Assembly in a historic way to facilitate people making that choice. But friends, what we're left with today is a choice as a legislator. As legislators, we've got to choose, do we want to let the child in the womb, a living, distinct human being, be torn from their mothers. There's been a lot of discussion today. There's been appropriate discussion about care for women and about the concern. Our hearts go out to every woman who would be harmed through abortion. But friends, every single year in this state, 30,000 children are not just harmed, they're torn limb from limb. Every single abortion takes the life of a human being. And friends, I'm not going to show it because it's not polite to show. On my computer screen is the picture of the contents of an abortion. It's right here. Now, why do I not put this on the board? I'd be booed and hissed if I put a picture of an abortion up on the big board. It is so inconceivable what happens in the practice of abortion that we can't even look at it. I can't turn this screen around without getting boos and hisses because it's so outside of polite conversation. The ripping apart of human beings through abortion is the reality that none of us want to face. It's so outside of polite conversation, we can't talk about it in our churches. We can't talk about it in the public square. It's something we don't want to face. In fact, a member of the press asked me, what do I wish we had been able to do in committee yesterday after 3 hours of debate? I said, friends, I just wish we could come face to face with the little parts of a baby and a doctor's hand that shows this is what abortion is. This is what we're talking about, friends. This bill weighs the privacy interest of the mother, which we recognize as being valid. But when you weigh the life interest of this human child, how do we reconcile those two in a fair, balanced, and appropriate way? I would ask you, if I were to turn the screen around and show you, and if I were to show 11 million Georgians what's on this screen right here, the product of an abortion, how do you think they'd vote? What do you think they think? Should this child be protected? Or should we go on with platitudes about trusting people's decisions? Friends, we have a very difficult balance to strike. And what I'm asking you to consider is this isn't not a new idea. This isn't something we made up in 2019. My friend, the lady from DeKalb, mentioned the Hippocratic Oath. The Hippocratic Oath was the foundation of modern medicine in the Western world. In fact, it was written, and the earliest records are for about 300 BC when the Hippocratic Oath was first written. I'm going to read from the Hippocratic Oath. I would ask you to join. I can't read the whole thing, but I'm going to read a couple sentences. It says, I will use treatment to help the sick according to my ability and judgment, but never with a view to injury or in wrongdoing. Neither will I administer a poison to anybody when asked to do so, nor will I suggest such a course, and similarly, I will not give a woman the pessary to cause abortion. 2,300 years ago, 23 centuries ago, the pagan Greeks recognized that taking the life in the womb is always unacceptable. Friends, this is a historic decision you've got to make. It's not easy for any of us. It is not easy for me to stand here. I stand here with deepest humility. I'm inadequate to communicate the enormity of this question. But with 60 million children across the country in the last 46 years have been lost to this barbaric procedure, when women are faced with such tragically difficult circumstances, friends, let's choose life. Let's help them make the loving choice of adoption and give people life. Let's draw the balance when there's a presence of a human heartbeat and say if there's a beating heart, if there's a beating human heart inside of a human being, they're worthy of our protection. Friends, I'm honored to be able to speak before you today. I'm humbled to serve alongside of you. And I ask you to join me in supporting House Bill 481. I yield the will.
The previous question has been ordered. What purpose does the minority leader rise?
Mr. Speaker, to make a motion.
State your motion.
Pursuant to Rule 152, I move this House adjourn.
Their objection? There is objection. All those in favor of the gentleman's motion? All those in favor of the gentleman's motion to adjourn will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? If so, the clerk will lock the machine on the motion to adjourn. The ayes are 66, the nays are 95, and the motion has failed. What purpose does the minority leader rise?
To make a motion.
State your motion.
Pursuant to Rule 93, I move to lay this matter on the table.
Is there objection? Have a motion to table. All those in favor of the motion to table will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the motion to table. The ayes are 70, the nays are 96. The motion to table has failed. The previous question has been ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 481. The ayes are 93, the nays are 73. This bill, having received the requisite constitutional majority, is therefore passed. What purpose does the minority leader rise?
Mr. Speaker, to serve notice pursuant to Rule 143 for a motion for reconsideration.
I think we have to take that up now. All those in favor of reconsidering the House's action in giving a constitutional majority to House Bill 481 will vote aye. Those opposed to reconsideration will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the gentleman's motion to reconsider, the ayes are 73, the nays are 93. This House has failed to reconsider its action in giving a constitutional majority to House Bill 481. Clerk will read the caption to House Bill 454.
House Bill 454 by Representative Tanner of the 9th. To be entitled an act to amend Title 40 of the Official Code of Georgia annotated relating to motor vehicles and traffic, so as to provide for the operation of motorized mobility devices and to provide for related matters. This bill having been referred to the Committee on Transportation, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Tanner to present the bill.
Thank you, Mr. Speaker. For the last several months, GMA has been working very closely with the scooter industry. This is an issue we didn't hear a whole lot about up until about 6-8 months ago. They worked very closely with the scooter industry in the cities, larger cities around Georgia, including Atlanta, to put some definitions in the code defining what the scooters are, and to setting up some basic rules of the road that allows for permissive use in bicycle lanes, permissive use on streets if there's no bicycle lane and the street is less than 35 miles an hour, and they also are allowable on sidewalks if allowed by local ordinance. They also allow local governments the flexibility needed to develop public strategies, safety strategies for roads within their jurisdictions. They create liability limits, and they also set minimum standards for parking, removal, including a Good Samaritan statute. They create requirements for accident reporting. This bill in no way restricts local governments. Local governments can further restrict or ban scooters, but this does set some basic rules of the road into the state law, which is much needed by the industry and wanted by GMA in our cities across Georgia that have this new technology. With that, Mr. Speaker, I'll be glad to answer any questions, but I'd ask for favorable consideration for House Bill 454.
You have no questions.
I yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 454. The ayes are 133, the nays are 28. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 470.
House Bill 470 by Representative Saints of the 180th and others, to be entitled an act to amend Article 6A, Chapter 3, of Title 35 of the Official Code of Georgia annotated related to DNA sampling, collection, and analysis, so as to provide for analysis and collection of DNA for individuals charged with felony offense but sentences to first offender. This bill having been referred to the Committee in Judiciary Non-Civil. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Saines to present the bill.
Thank you, Mr. Speaker. I rise before you today to bring up House Bill 470, which changes Title 35 to reflect modifications made in Title 42 in 2016 on first offenders. It makes it to where, which made it to where first offenders were not labeled as a conviction. This purely makes it to where Title 35 recognizes both convictions and first offenders in collecting that DNA. It also adds added protection that the DNA collections automatically discarded after that individual's done with the first offender sentence. With that, I yield if there's no questions.
You have no questions.
Thank you, Mr. Speaker. I ask this body for its favorable consideration.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 470 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 470. The ayes are 143, the nays are 15. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 478.
House Bill 478 by Representative Ballinger, the 23rd, and others to be entitled an act to amend Article 8 of Chapter 5 of Title 49 of the Official Code of Georgia, annotated relating to the Central Child Abuse Registry, so as to provide improvements to the operation of the Child Abuse Registry. This bill having been referred to the Committee on Juvenile Justice. That committee recommends that this bill do pass.
Chair recognizes Chairman Ballinger to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, the evening grows long, so I will be very brief. Section 1 is it just updates the language. Section 2 eliminates juveniles to the Child Abuse Registry, and it adds the information that needs to be submitted. Section 3 sets forth procedures and allows for the opportunity for a hearing before the placement on the registry. Before, you had to appeal to actually get off the registry, and it also allows for a stay when there is a criminal prosecution. Section 4 covers the expungement provision. This is a consent piece of legislation supported by GACTL, PAC, the Barton Law Center, Voices for Georgia's Children, the Division of Family and Children Services, and many others. Mr. Speaker, I'll be happy to yield for questions.
You have no questions.
Thank you, Mr. Speaker. I ask for your favorable consideration. Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 478 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 478. The ayes are 151, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 84.
House Bill 84 by Representative Smith, the 134th, and others to be entitled an act to amend Title 33 of the Fiscal Code of Georgia Annotated relating to insurance so as to provide for consumer protections regarding health insurance. This bill having been referred to the Committee on Insurance, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Smith to present the bill.
Thank you, Mr. Speaker. For you freshmen, I've been working on this bill 4 years, so don't give up when you get started on something. This bill has to do with transparency. And, you know, you go to the hospital, you've done everything right, you've talked to the hospital, they're in your insurance network, your doctor's in your insurance network, and then all of a sudden you get home and about 4 weeks later you get a bill in the mail, sometimes 6 months, sometimes 12 months, and there's someone you know here, and I'm not going to tell you who it is. She received a bill 3 years after a procedure was done. Now that's obscene. This bill just says that if when you go in for a doctor's office or for a hospital visit, that upon your request, they have to tell you the providers in that procedure. They have to tell you if they're in your insurance network. They have to tell you what the cost is. And for these are normal procedures. And they also have to tell you how much your insurance paid so that you know if you have a bill coming. Then at the end of that, instead of getting these bills 12 months later, 3 months later, or whatever, they have to send you the bill within 90 days after the final adjudication with the doctor's insurance, hospital, and this, and then you have 90 days to respond. And you can do an alternative dispute resolution through the insurance department. So there are mechanisms to protect the hospital and also doctors and also the patient. Mr. Speaker, I'll yield for a couple of questions. Otherwise, I appreciate your support.
You have a question if you care to yield.
Yes, sir. I'll go for two.
Chair recognizes Representative Newton to your right for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, I do.
I know the gentleman will agree that you and I have both worked on this challenge, and I appreciate your work on this to end the surprise insurance gap, the surprise billing. Is it true that this bill does not solve any of the emergency bills that someone would get or any of the bills from on-call doctors?
That's exactly right. This is just for scheduled procedures.
Will the gentleman further yield?
Yes, sir.
I know there's disputes among constitutional lawyers, of which I'm not, and didn't play one on TV or anything. Is it the sponsors' concern that there could be a possibility of another bill that would come from the other chamber that we could hope to look at, and at least at a hearing or a possible vote on this House floor, that might solve both the emergency consumer problem as well as the...
I think you're referring to Senate Bill 56, and I've already promised you that we would have a hearing in subcommittee on this particular issue, which is something we haven't done in the past, because based on legislative counsel's advice on this particular item, on Senate Bill 56, they say, I see it as an unconstitutional impairment of contract and restraint of trade, could also be an overreach of legislative power, and in the right circumstances, an unlawful delegation of power. So we will have a hearing, but a hearing only now.
Thank you, sir.
Mr. Speaker, I'll
No,
yield
no
the will.
further questions. You do have one. Now he waves. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 84 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 84, the ayes are 77, the nays are 78. This bill has failed to receive the requisite constitutional majority. Clerk will read the caption to House Bill 264.
House Bill 264 by Representative Werkheiser, the 157th and others, be titled an act to amend Article 4, Chapter 5 of Title 21. The official code of Georgia annotated relating to public officials' conduct and lobbyist disclosure, so as to provide that any natural persons undertaking to promote or oppose any matter before a local coordinating entity regarding the emergency medical systems communication program are subject to transparency. This bill having referred to the Committee on Health and Human Services, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Werkheiser to present the bill.
Thank you, Mr. Speaker. I'm going to speak fast. This bill came about because constituents from all over the state have asked that we looked at how our ambulance services are selected and reviewed. Currently, our state is divided into 10 regions or coordinating entities that select and oversee our ambulance services. The first section adds that those who promote or oppose matters before these councils be subject to the state ethics and transparency laws. Secondly, these councils would need to establish bylaws which must be approved by the Department of Public Health. Thirdly, anyone who operates or owns or submits a proposal shall be prohibited from serving on any of these committees. Lastly, the bill adds these entities to the open meetings requirements. There's other provisions such as appeal processes, accountability standards, and reporting requirements that are included, and you can read for yourself. With that, Mr. Speaker, I'll yield the well.
You have no questions. Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 264. The ayes are 148, the nays are 6. This bill, having received the requisite constitutional majority, is therefore passed. I want y'all to help me recognize a outstanding group of young people that have been with us all day long. Our pages for today. Thank you all very, very much. And while you're in a good mood, the chair is going to get us out of here so that Representative Mary Margaret Oliver can have about 50 minutes to celebrate her birthday before midnight. Please wish a happy birthday to Representative Oliver. On the floor of the House, we have yet another former member, former state representative, now Judge Mike Jacobs. The chair recognizes the majority leader of this House for a motion.
Mr. Speaker, I move that this House stand adjourned until 10 a.m. Friday, March 8th, 2019.
And as I understand, I hear groans, weeping and wailing. We will have no rules calendar, but we will have first readers tomorrow, so we can get bills that have come over from the Senate. There were some that we did that they didn't touch. I'll have more to say about that later. But they've sent some bills over, and we're going to put those in committee tomorrow. And so we'll be here at 10 o'clock, and we'll get you out of here very quickly. The majority leader has moved that this House adjourn until 10 a.m. Friday, March 8th. All those in favor of the motion will say aye. Those opposed will say no. The ayes have it, and this House will be adjourned until 10 a.m. on Friday, March 8th.